Anthony Young.
No.
So, Mr. Young, you were previously in court. You entered pleas of true in a motion to revoke your probation. You're on probation for theft of a firearm, which is a state jail felony. And I was just looking at the old PSI and it had F2 beside it, but we're all state jail felony.
Yeah.
And so you entered pleas of true that you violated your probation and you were sent to, okay, I just want to kind of go through. I've received an updated pre-sentence report. Has everyone had an opportunity to review that?
Yes. Yes, sir.
Any additions or corrections to that report?
No, sir.
And then I've also received, and we've been talking about these throughout his court appearances, some updated jail incident reports. Have you both had an opportunity to review those as well?
Yes, sir. Yes, sir.
And so this is this was an unagreed plea. There was no agreement when we were here before. And so I also took a look at and was able to review again that underlying offense pre-sentence report as well. If anybody has any questions, you're welcome to look at mine if you don't have your copy of that. And so, Mr. Young, it sounds like you guys talked at least today about an agreement for an 18-month term in the state jail, but I don't, based on what I've seen in this pre-sentence report update, the old pre-sentence report, and the incidents that have happened since we were in court last time, I'm not going to go along with any agreement. He pled unagreed. It's going to be up to me. I'll let y'all make argument. Mr. Lewis.
Well, Judge, this is a situation, of course, he was previously on probation where he was participating in a cognitive track of ISF when the initial incident occurred, and which I believe was maybe less than a week before he was to complete the program, and he was sent back. Since then, I've been in constant contact with his parents, his mother and father, who they
I think he was already there. This incident happened at ISF.
ISF, yeah.
Yeah.
And he was sent back from ISF like a less than a week before he completed.
2 days before he was supposed to.
Right.
Completed. But since then, I've been in contact with his parents, Judge, and they are very supportive of him in any way. As far as him going forward in the future, I did talk with him, so he understands that probation, of course, will not be probably the best situation for him. That's why we came to the agreement that we approached you about on the 18 months. Judge, we would still ask for any 18 months or close to it in order to allow him to finish cleaning out any time to support things that's deserving at this point, and he can move on with his life. His parents are available. His father actually lives out of town, which could be a benefit to get him out into a new situation, a new circumstance to where he can start his life over. So that's kind of where we are at this point, Judge. Ultimately, I know that decision rests with you.
Mr. Smith, anything else?
I don't think I need to argue, Judge.
There were 17 juvenile either offenses or failure to comply with the court order that ended you up in TJJD. So you've already been to juvenile prison and you got out of juvenile prison and you commit this offense. You're certified as an adult. I give you this great opportunity to go to ISF to get the tools you need, which you should have gotten in the first one was in 2019 to 2024. You're going through, you're on delinquent court probation. You should be getting all kinds of tools that you needed through the juvenile system. You should have gotten some more at TJJD. I give you an opportunity and you get to ISF and you just can't make it through. Then you get into our jail and you're told, stop getting in trouble. And you left court on the 24th and the first incident report was on that day. First one. After I said, don't get any more. And you went back and got one the very same day. And you've had 8 since then. You like to smoke. You like to do what you want. like to horseplay, you like to, I mean, you're still acting, unfortunately, like a child, and you're not a child anymore. And you've been told that, and you've been given these tools. And at some point, you've got to get truly a wake up call. And I think it's great that your parents are supporting you. You should have probably been living with your dad about 4 years ago if he's out of town. If that's what y'all are saying is helpful, then maybe sometime before the 17th time you got in trouble as a juvenile, somebody does something. And that didn't happen. You just kept doing it. So if they're there to help you, you're sure not taking advantage of it. And that's on you, not on your family. If they're trying and you just choose to go run the streets and do what you want, which is what you've been doing. I mean, you had a robbery. We're not talking about just little things, right? I mean, we've got terroristic threat, criminal trespass, running away, assault bodily injury, assault family. So your family's trying to help you and you're assaulting them. Expulsion from your school, theft, robbery, aggravated assault, assault causing bodily injury to a family member, terroristic threat, criminal mischief, escape while you're confined. I mean, that's crazy that that all happened while you were juvenile. And honestly, that the most I can do today is 2 years. Somebody needs to protect, looks like a whole lot of people from you. And that's the only thing I feel like I can do today. So I'm going to find that you entered your pleas of true, freely, and voluntarily. Find those counts true again. Find sufficient evidence to find you guilty. And at this time, find you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not an agreement. You have some limited rights to appeal. You can talk to Mr. Lewis about that. I'm also going to hand you a trial court, a written admonishment that explains that because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you, another felony. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lewis. And so what you do with this time, Mr. Young, is going to be up to you. It's not a lot of time. You're going to be out. You're going to be real young. And then it's going to be up to you whether or not you want to change your life or not and get the help that your family's saying that they'll give you. But if you choose not to, then you're just going to be, it's just going to get worse and worse and worse. And you're going to spend the rest of your life in prison if you keep doing what you're doing. Does that make sense? I need you to sign this and you'll get a copy of it. And Mr. Lewis, y'all get the bottom 2 copies. Okay, so back on the record with Mr. Mark Garcia, 25 PCCR 0120. What's going on? What's the announcement?
Judge, I got a new offer from the state. I talked to Mr. Garcia about it. He did want me to look into some of the things with his prior convictions.
Okay.
He had questions about some of those. I believe just thinking offhand, I think what the confusion is, I just need a few days to speak with him and get him to understand what's going on.
Okay, and there's been an offer made.
Right.
Yes, it's a TDC offer to the second degree judge, and what we discussed was that the confusion may lie with the fact that the state jail conviction resulted in the 1244 county jail time is still a state jail conviction for the case with.
And I think it would be a 3rd degree because it's 2 state jails. Yeah. So it looks like there's 2 sets of state jail convictions. There were 2 in 2022, and then there were 2 in 2023 on the same date. So that would make 2 sequence state jails, which would make it a 3rd degree. Okay. All right. I'll just do a normal reset, give you some time to visit with Mr. Garcia. Mr. Garcia, talk to Mr. Lewis. He's obviously aware of what the law is, and he'll look at those judgments that the state has, and we'll get an announcement at the next court date. All right. Thank you. Good afternoon. Are you Devontae Savoy?
Yes, ma'am.
And this is cause number 23 DCCR 2038. Mr. Savoy is on probation for tampering or fabricating physical evidence with intent to impair. There's a motion filed. What is the announcement?
Judge, and I've spoken to Savoy, and at this time he'll be entering pleas to the motion.
Okay, so there's no agreement.
No agreement, Judge.
That pulled up.
I believe we had an agreement of sorts.
Well, Judge, I'll say that the issue is, of course, is instead of talking with the state, we definitely want to get an updated PSI for Mr. Savoy for making any determination whether the options may be out there on him, but to the actual violations, he's more than willing to enter his pleas to those.
Okay. But y'all don't have an agreement with regard to punishment.
That's correct, Your Honor. And I spoke with Ms. Lopez, his probation officer, and we all thought that an updated PSI might be very helpful with that.
Okay.
And then just as a clerical matter, Your Honor, I noted that number 6 violation, alleged number 6 is arrearage. Number 15 is an updated amount of arrearage, and so the state will abandon number 6
Thank you.
for number 15.
So I just did a prior version thing. It showed that there were 2 First Amendment motions. One's an order and one's the actual motion. And so now there's a prior version of an order too. So just in case y'all look and see that. Okay. So Mr. Savoy, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. You can put your hand down. Thank you. And will he waive the formal reading of that motion?
He does, yes.
So, Mr. Savoy, in cause number 23, DCCR 2038, have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 30th of 2025 for the offense of tampering or fabricating physical evidence with intent to impair, a 3rd-degree felony, and that was a 4-year deferred probation. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you failed to report to the probation office as required August 8th, October 6th, October 31st, and November 14th of 2025. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 4 alleges that you failed to provide verification of participating in and complying with all of the rules and guidelines of the Mental Health Initiative caseload. Is that true or not true? Count 5 alleges that you failed to participate in the education program for your GED. Is that true or not true?
Yes.
And then the state abandoned count 6. Count 7 alleges that you failed to have the drug patch on as directed. Is that true or not true?
Yeah.
Count 8 alleges that you failed to enroll in services at the Spindletop ATAR program. Is that true or not true?
True.
Count 9 alleges that you committed the new offense of failure to ID on February 26th of 2026. Is that true or not true?
True.
Count 10 alleges that you committed the new offense of theft of property February 26th of 2026. Is that true or not true?
True.
Count 11 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically association with any person previously convicted of a crime or at the presence where a crime was being committed. Is that true or not true?
True.
Count 12 alleges that you failed to report October 1st of 2025. Is that true or not true?
True.
Count 13 alleges that you failed to immediately report to your probation officer your change in contact information. Is that true or not true?
True.
Count 14 alleges that you were at a location other than your residence at approximately 9:21 p.m. February 26th of 2026. Is that true or not true?
True.
And then finally, count 15 alleges that you're behind in your court-assessed fees as of March 3rd of 2026 in the amount of $1,220. Is that true or not true?
True.
Did you enter your pleas of true to all of the counts except 6 that we left out freely and voluntarily?
Yes, ma'am.
And did you plead true to all of those counts because they're actually true?
Yes, ma'am.
All right, then, and this time I'm going to find that you entered your pleas of true to counts 1 through 5 and 7 through 15 freely and voluntarily. Find those counts true. find sufficient evidence to revoke your probation and find you guilty, but I'm not going to do that today. I'm going to reset your case for sentencing, ask the probation department to do an updated report that'll give me more information about what's been going on, and then we'll see where we are at that hearing. If there's some agreement, great. If there's not, then it'll be up to me what to do with your probation. Okay?
Yes, ma'am.
All right, you can go back with the bail. Yes, ma'am.
I would add, one of the ones that he pled